The topic of today's webinar is the DEI certification, what's happened and what's next. I want to introduce myself briefly as well as my colleague, Dan Scharf. So I'm Adam Blaylock. I am a counsel attorney here at Miller Johnson. I have been in and around education for my entire legal career, but I also spent 4.5 years as a school district administrator. I was the director of human resources at Lincoln Consolidated Schools. Now I get to help you with all the issues that we deal with today. But I also want to introduce briefly my colleague, Dan Scharf. Dan just joined us at Miller Johnson about 2 months ago now, after spending 18 years with the U.S. Department of Ed. But I want to turn it over to him briefly to be able to give a little bit of his bio, because he knows it a heck of a lot better than I do.
Yeah, thanks, Adam. So like Adam said, my name is Dan Scharf. I joined Miller Johnson about 2 months ago. I had spent the last 18 years of my legal career with the U.S. Department of Education's Office for Civil Rights in their Cleveland regional office. I had been thinking about maybe making the transition to private practice for a while, and I might have seen some of you guys before in my previous role doing investigations and mediations. Fortunately, I was offered the opportunity to come to Miller Johnson. I started on Monday. The Tuesday after I started, the U.S. Department of Education's Office for Civil Rights regional office in Cleveland was closed. So I feel like my timing was like really great for me. Whether it's great for the universe remains to be seen. And that's some of the stuff that we'll talk about today. So thanks for giving me the opportunity to speak today.
All right, so we're gonna move into it. We're gonna start with our general slide from our general counsel that says that this is not legal advice. So everything we're going to talk about today, in terms of questions, answers, whatever it may be, it's all hypothetical. I promise. I mean, absolutely hypothetical. But ultimately, the reason that we're here today is that we want to talk a little bit about what just happened, and really. I remember starting on April 22nd through that period when the certifications were purportedly due and the preliminary injunctions on April 24th. I remember getting to the end of one of those days and counting through the phone calls that I'd received, and it was somewhere around 30 phone calls over the course of the day. And I know that that's part of the reason that there's an appetite for this material, is because the reality is we're still digesting a little bit about what's already happened. But ultimately, we want to talk a little bit about what Dan and I think is going to happen. So today's presentation is really going to be broken into 2 parts. Part 1 is going to be trying to make sure that everyone in the room understands what has happened, what just happened in this April period, because things happened so quickly that it was really difficult to manage. And then the second part of our presentation is going to be focused in on what do we think is going to happen next. And so Dan and I have slightly different views on that. And so you're going to see us go back and forth and play a little bit of good cop, bad cop, where we argue a little bit. But ultimately, the goal is to give you the tools to be thoughtful and mindful about the things that I would be considering as we move into this era with the current administration and the way that they're approaching these things. So with that, I'm going to turn it over to Dan to kind of outline a little bit of the timeline and what's going on here.
Sure, thanks. So I think everyone here is keeping up with this news. Every time there's an administration change, things change at the U.S. Department of Education and across the board for all executive agencies. This was maybe more of a shift than previous ones had been. We got a new Secretary of Education, which is very typical. We also got a new acting assistant secretary for OCR. And while every assistant secretary for OCR has a really strong point of view, sometimes they come out slow and sometimes they come out a little bit more quickly. So we have Linda McMahon here, but this all predated her a lot of this predated her formally joining us. But these are the things that we're going to be talking about really briefly. We're going to be talking about the initial Dear Colleague letter that OCR issued. That told everyone this is what's really important to us right now. This is our priority. This is our enforcement priority. Then we dealt with the certification requests that caused a lot of indigestion and a lot of lost sleep for a lot of people. And then we got the court decisions, which everyone was waiting for, which nothing's over yet, but we got a little guidance on what we at least need to do for, this week, next week, and maybe the week after. So first, the Dear Colleague letter, which, my perspective, having been at the Department of Education, is, pretty obviously different from yours. But in general, I think, if you get a letter that says, Dear Colleague, just like when someone walks up to you and says, Hey, friend, it's probably not going to be the best thing ever. So I think that's what happened here, where right off the bat, you'll see we have the seal for the Department of Education, then we have the Acting Assistant Secretary, Craig Trainer, who came here seemingly with a pretty singular purpose to stamp out impermissible or illegal DEI. And what was being used as the vehicle to do that was the admissions case from Harvard, where, you had this narrow court ruling that was saying, this is, you cannot consider race, at least in the way that you have previously, with respect to admission to college. It's not permissible. Now, that was a college admissions case, but through the Dear Colleague letter, which is a way that agencies will not create new law, but will say how they're interpreting existing law, Craig Trainer came out and said that we're going to be applying this, we're being the U.S. Department of Education, to all K-12 educational entities and post-secondary educational entities, so colleges and universities. Oh, and by the way, you've got 2 weeks to get rid of all your DEI programs, basically. That was the short of it. So this was an interesting time. This was also the time where I was wondering, is the U.S. Department of Education's Office for Civil Rights a great place for me to be at February 2025?
One piece that I want to put a point on for Dan is like the changeover in kind of policy decision making in such a short period of time. Anyone that's worked inside a K-12 institution understands that mid-February is actually an incredibly difficult time to make meaningful changes. You're a little bit more than halfway through the school year. You're focusing and you're starting to look towards the end of that school year and next school year. So the timing on this was obviously also far from ideal. But I'll turn it back over to Dan.
Yeah, and this is and as far as from a bureaucratic standpoint, it's pretty typical that when a new administration takes over, there's a pause, and the pause could, there'll be an enforcement pause as the new administration is getting their footing and figuring out what's going on. The joke used to be at the Office for Civil Rights was, this is a safe agency to work at because any new administration will take 2 years to figure out where we are and another 2 years to figure out what it is that we're doing. Now, that was before the work that was being done at OCR became front page fodder. So everything changed. So what was kind of like a backwater agency that was really pretty narrowly focused on just a couple of civil rights laws as they relate to schools became really involved in the cultural flashpoints that were going on, especially post-COVID. So that's what happened. And then, you add to that a new administration that comes in that has the history from having, they know where all the bodies are buried. It was an administration that knew where all the levers were. Similar to the previous administration that came in with the previous assistant secretary for OCR, that they're able to get the ball rolling a lot faster. And that's what happened. So there was a pause while all this stuff was being queued up, and then everything came pretty fast and furious. So we have Judge Judy. She's frustrated, but it's happening. And this is, the Dear Colleague letter led to this request for certifications. And this is where I'm going to turn it over to Adam to take over.
Mm-hmm. So as folks will recall, on April 3rd, 2025, the OCR U.S. Department of Ed sent to all the state education agencies, including Michigan, this request for certification. And it uses some extremely specific language in terms of what it's targeting. But some of what was in those prior guidance documents, including that Dear Colleague letter and then an FAQ that were issued by the U.S. Department of Ed, are part of what gave me indigestion. And the reason for that is that they specifically referenced a couple of concepts that are, I think, very common in our schools, even if traditional DEI, as the Biden administration would see it, is not. And the biggest one is social emotional learning. There was an FAQ issued by the U.S. Department of Ed on March 1st or so that specifically cites to social emotional learning as a veiled attempt to discriminate. And I have my own theories for where I think that comes from, but ultimately that has been, I think, a potential target for what the U.S. Department of Ed is looking at when they're trying to enforce this prohibition against DEI programs. But anyway, as we return to that April 3rd certification requirement or request, there were a couple important pieces. It invokes that the Schools for Fair Admissions case, that Harvard admissions case. It specifically talks about the use of illegal DEI, and it threatens enforcement. And it threatens enforcement through a way that traditionally these statutes have not been enforced against K-12 school districts, and that's through this False Claims Act concept. And that is an area that I think is new for most schools and is particularly troublesome. And the reason that I'll say that is going to be on our next slide here, because what the heck is a false claim? And so what the False Claims Act does is it prohibits a person or an entity from knowingly, so having knowledge of something, and still submitting a false claim to the government in order to receive government funds. So the hidden piece behind this certification is this idea of enforcement under the False Claims Act. Now, as Dan can speak to in a way that I can't, but I've been on the district side of OCR enforcement actions. Those things can take a while to work their way through the system. The False Claims Act deputizes members of the public to enforce these statutes, though. And there's really two really important pieces related to False Claims Act enforcement. And that has, I think, been the point of emphasis from us as well as other law firms that are supporting our school districts with this, is that the damages can be trebled, so tripled, and also includes attorney's fees and penalties. And it can be brought by a member of the public. So Dan has already shared that there's been a tremendous amount of turmoil in the U.S. Department of Education as this administration has put its fingerprint on it, both in terms of the number of folks that are at the U.S. Department of Ed, as well as the way that they're structuring some of the enforcement components. But that doesn't matter as much if the public is able to enforce these things. And I think this concept in particular is part of what caused so much activity in late April for all of our local school districts. And candidly, from our perspective, you've got to be kidding me on this stuff. Because again, as I mentioned earlier, making these kinds of changes mid-school year is incredibly difficult, and something that obviously school districts were left in a position where they weren't able to know, based on the policy changes between administrations, what to do in those circumstances. But Michigan, as well as a number of other states, took a position as it relates to that April 3rd certification. The first one was New York. They came out and said, we already certify. And Michigan, Dr. Rice took a similar position on that. They say, hey, we already certify our compliance with Title VI and these other federal civil rights laws. We're not going to be submitting another certification. And that provided a little bit of a shield for our local school districts at that time, until April 22nd, 2025, which is, I think, what prompted the entire flurry of activity. So at that time, the Office of Civil Rights and then MDE forwarded along their communication, shared that locals could self-certify by emailing the Office of Civil Rights at ed.gov. Dr. Rice forwarded it to all of our locals. And then, as everyone in this room is aware, chaos ensued. I know there were superintendent groups across the state that were meeting. I was fielding dozens of calls, as were others on our team. And we were ultimately trying to figure out what exactly is going on and what's the best guidance that we're able to offer. And I know that this was the reaction from a number of our locals. But the guidance that we came up with, and I think was consistent with some of our other colleagues and competitors across the state, was pretty simple, and it was hold the line. And the reason for that is because we were aware and knew that there were court cases coming and pending related to these issues. And that's really where we really reached the pinnacle of all of this. And I'll turn it back over to Dan for a few minutes to talk about those federal court decisions.
Yeah, thanks. And I think that, it was interesting to see these emails coming to the states as opposed to the local school districts. And I think that really reflected kind of what was going on at the U.S. Department of Education at that time with respect to enforcement. So, what Adam was saying with deputizing citizens to do the work and basically incentivizing them to, suss out illegal DEI. And similarly, or relatedly, I should say, going to the states and saying, I want you guys to make sure, your locals are doing this the way we want it to be, is because frankly, the people just weren't at the U.S. Department of Education's Office for Civil Rights offices to do the work. And we'll talk about that a little bit more later, but it's these big threats because the traditional enforcement mechanisms just weren't available in the way they historically had been. So, just to keep it exciting, to get everyone to bite their nails a little bit, at the last minute, the courts came out. Hat tip to Adam, who's like, I just know this is gonna, I know not to go out for lunch on the 24th because this is gonna drop. And sure enough,
I gotta pause Dan for a second because that morning I literally texted our group and I was like, I have an eye doctor appointment at noon. That's when it's gonna happen. And I'm sitting there in the lobby of my eye doctor, and what do we get? The notification that the first injunction had been ruled on. So I'm sorry, I interrupted.
No, you knew not to get dilated. You were ready for this. You were ready for this. So the New Hampshire court decision, I think, which is the one, I think that's the one that people were watching the most closely. That one comes out and they enjoin the enforcement for the certifications, but not just for quite a few school districts, but not everyone. So you're looking at, do we have NEA employees? What does our district do? Does this apply to us? But then Maryland comes out, and it's a Trump judge that says, let's not talk about the certification request for a second, except to talk about how it flowed from the February 14th Dear Colleague letter. And that February 14th Dear Colleague letter is a complete change in your position, you're being the U.S. Department of Education's position on what the requirements were for how districts could stay compliant with Title VI. So when you have a big change like that, you can do that. There's constantly disagreements between administrations, even in the same party, on how statutes should be interpreted. But the way that's done is through the Administrative Procedures Act, notice and comment period, and rewriting the reg, not just simply issuing a Dear Colleague letter that's saying, this is how it's always been. Yes, Title VI has always prohibited discrimination based on race, color, and national origin. But when you're saying that even the same administration at a high level, 6 years prior, was touting DEI as a way that schools could ensure access to everyone and create fairness in the Title VI space, to saying, no, we've always been saying that this kind of stuff is illegal, it just didn't pass the smell test for anyone. And so the district court in Maryland, the federal district court in Maryland, said that, if you're going to go about changing the interpretation of the law, there's a way to do it. Sending out a letter that says, dear friend, dear colleague to everyone is not that way. So to the extent that the certification request flowed from there, that's bogus. And then the U.S. District Court in D.C. came out the following day, and they're just like, not only is that certification request bogus, but even if you already did it, don't sweat it. Which I think that probably Adam was probably able to take a deep breath with his, False Claims Act anxiety, which I think is well-founded. I joke about it, but they're just saying, even if you already signed it, don't worry about it. Now, it's very different for different states, right? In Ohio, all the non-major city states, they had no problem signing it, and the state didn't give them any cover. So they were signing this thing. Michigan and some of the other states on that pictured slide with all the flags, you had your Department of Education kind of giving you a lot of cover in that. So everyone did things different, but come that DC District Court decision, it said it doesn't matter, that certification holds no water whether you signed it or not. So then everyone's feeling tough. The cavalry comes in. Attorneys general from many of the same states that originally were not comfortable with the certification requirement, they came forward, they filed suit saying that the certification requirement, it's vague, it's confusing, it's an incorrect interpretation of Title VI. So basically saying, it's this idea that there's illegal DEI, which begs the question of, well, then what's legal DEI? And it kind of doesn't, multiple people, myself included, thinks that doesn't really make sense. Not only is it inconsistent with how you've been doing it, not only have you not gone through notice and comment and actually changed the regulation for enforcing Title VI, but also everyone's head is spinning. What is this? And why are we looking at a Harvard admissions case and applying it to every K-12 school in the country? It led to a lot of confusion. And that's a Dear Colleague letter. Traditionally what that does is it says, hey, here's a reminder. This is how we've been enforcing the law. This is how the law is enforced. And by the way, wink, wink, like this is going to be a priority for us for the next couple of years. Now, I would say that in the 18 years I worked for the Department of Education, I think every Dear Colleague letter probably tweaked it or pushed it a little bit. You wouldn't find universal agreement with regards to the interpretation of the law. They were notifying, schools that it was going to become an enforcement priority. However, I would argue that this is the most wholesale change I saw in nearly 20 years from having worked at the department. So that brings us to the present, right? Because we got through all that. And I'm just going to talk to you about kind of what do we do in the current landscape, and I'll jump in as appropriate.
Well, and so one thing that I want to, in order to have some context related to what happens next, is that the court decisions that have been issued right now are all preliminary. And the question that I would pose to Dan, as someone that's worked on the inside, is this: does this mean this is the end of this? Do these court decisions mean that this is over at this point?
Yeah, and I think that not at all. I mean, you could look at the language in the court opinions and see that there are varying degrees of frustration with the administration, but where they landed was, for the most part, at this stage, we're just paused, right? None of these cases are over. This is just kind of a stopping point for everyone to reconvene their troops, bring them back, feed them, and get them ready to go again. And the big thing, I think, the strongest argument for what was wrong with the certification request, with the theories postulated in the Dear Colleague letter, was that the administration failed to follow the Administrative Procedures Act, which is a way of saying that they can fix this. The administration could overcome what we're seeing as the greatest the problems that were fatal for them pushing the certification requirement at that time. So no, I think we're just getting started. And I think that there's probably multiple prongs that we're going to see the administration come forward with. And one is they're going to keep fighting it in court, right? They're going to say these preliminary injunctions are no good. You know, you're already seeing it where there's a lot of pushback with, can a little district court, you know, enjoin something for the entire country? And I think that, you know, we're gonna learn more about that, and we're gonna see how hard the administration pushes on that issue. But more so, if they go back and do this correctly, it's very similar to the way that you're seeing, you know, the layoffs or the firings at the agency's work. It's not that they couldn't fire people, right? Like under the Clinton administration, tons of government workers were let go, but it followed the proper process. You know, where you're seeing the arguments here is it's not that they can't cut all these people, although there's a question of, can you cut so many people that you make an agency unable to fulfill their congressionally mandated duties? But what you're seeing that that they didn't follow the process. And one thing that I can say from having been through multiple administrations at the government is that this administration, they do know how to follow the process. You know, you saw Title IX that they went and they changed a regulation, which was a very difficult process, a process that kind of the Department of Education avoids for years and years and years, because there was always this concern of, how do we have the resources to do this? Can we do this? But they did it. And then you saw the Biden administration did it again, and then it went back and forth. But no, they know how to change a reg if they want to change a reg. And this seems very close to their heart. And, you know, particularly right now, there's the acting assistant secretary, who's Craig Trainer. They've already named who's going to be the secretary if she gets nominated. She is someone that has a history in education. She's someone that's maybe, you know, that's been in this place before, maybe not as much of a ideologue. But she's not there now. And they don't seem to be in any great rush to drop this, you know, philosophy, I guess I'd call it, with how Title VI should be applied to K-12 schools. So no, I think right now you get a breather, but I think this is definitely coming back.
Which leads us into reading the tea leaves and trying to figure out different ways to manage this. And this, I know at the outset, I said that there was some, I wouldn't, disagreement's probably too strong of a word, but like different perspectives that Dan and I have on some of these issues. So we've got a couple of concepts that we want to talk about. We want to talk about insurance coverage and what enforcement actions are looking like already. Certifications that we might expect for the administration to request or demand on a going forward basis. A little bit about these lawsuits and appeals, and then ultimately how to be practical. One thing that I'll say at the outset is that there's no one size fits all with this right now. And that I know is unsatisfying for some of our clients and some folks around the state. But the reality is that the risk tolerance of different districts and also the belief in how ingrained some of these practices are in the institution are things that are going to continue to be dealt with on a district by district basis. And so, as we often do as lawyers, and I know it frustrates our clients, but much of our answers when we're talking to a broader audience like this are going to be, it depends. And candidly, when I was talking with different clients on the 23rd and 24th, I told clients to certify and I told clients not to certify based on the particular circumstances in their district. Although I did tell all of them to wait until the end of the day. So let's get into what I think, and is probably the issue that I've been very focused on, is insurance coverage under this False Claims Act claim. And this is something that I was able to connect with one of the insurers that insures a number of school districts across the state, although not all of them. And I was able to get their feedback and perspective on whether or not coverage would be granted under one of these False Claims Act claims. And the reality is that it's unlikely that coverage would be granted. And because of the way that those False Claims Act lawsuits are structured, we're talking about potentially really significant damages claims, as well as an incentive for those private plaintiffs to go after folks. And so one of the discussion points that our group has had is the creation of what I would almost call a cottage industry of going after school districts that have DEI practices in order to sue them under these False Claims Act type lawsuits because of how big the damages are. And I think that there will be, I think there will be a push on the plaintiff side of the bar, those that sue school districts, to try and do these things. And so, what I would suggest is like this is a thing that if you have not done so, I would check and confirm with your insurer what the coverage looks like, because my suspicion is that there isn't any coverage for most school districts for a successful False Claims Act claim. And ultimately, there's a number of exclusions in the coverage language that and the potential return of federal funds that I think is potentially catastrophic for the operations of a number of our school districts. And so as I was giving guidance and talking through these issues in late April, one of the things that I was saying is that depending on what our practice is, given how significant this is, that may dictate the answer. And it may for your particular institution. And ultimately, when it really comes down to it and push comes to shove, the reason that I was telling some school districts not to certify is because I know that they already have an active population that would attack their organization for these practices. And if they had not already taken steps to divert and shift away from engaging in that certification, then they were potentially subjecting themselves to really significant risk under the False Claims Act.
And there's so many places that threat could come from, whether it's a disgruntled employee, a member of your community, or someone, sitting at home on their computer. I mean, you saw with web access complaints how that swept through the country. To a lesser extent, that happens with playground accessibility complaints. It happens with parking lot cases where people could just get on Google Maps and make it's very easy for someone from anywhere to try to have a major or a minor payday based on this kind of claim.
We did get one great question that I want to address immediately. The question was whether or not school districts are already subject to False Claims Act actions. And the answer is yes. The difference relative to the certification request is what you are certifying to. So school districts on an annual basis submit certifications to the state that the state then passes along to the federal government. And this is all set out in regulations saying that they comply with Title VI. And I think that was the stance of Dr. Rice when he was responding back in his letter response to the initial request for certification. So the difference between where we were under prior administrations and where we were on April 3rd is the type of certification that we were making and the potential risk associated with that. That's the big difference.
Yeah, if I could to just jump on that, I think it's obvious, but in case it's not, you weren't just agreeing that you were complying with Title VI with those certification that was presented. You were agreeing that you were complying with this pretty wild interpretation of Title VI. So when you're normally certifying your compliance, you're certifying your compliance to, basically what everyone agrees has always been the law. It wasn't just, I agree to Title VI. It was, I agree to Title VI with respect to, this is what I am agreeing that Title VI means. And I think that was the difference with the False Claims Act there. Sure, someone could say, you agreed to Title VI last year, and look, with the Harvard admissions case, now Title VI means this, and that. Sure, they can make that argument. I think that their argument is much stronger if they're saying, and you signed a document that says you are codifying your district's agreement with this confusing, bizarre, different, strange interpretation of Title VI.
Okay. So we're going to turn to a little bit of what's been announced in the aftermath is that we are starting to see some meaningful enforcement actions by the U.S. Department of Ed. And this right here is, I would call Dan's wheelhouse, but maybe not these particular actions because it wasn't with the department when they started.
Yeah, these are new, but this is kind of more I don't want to call it a breath of fresh air, but like a glimpse of, in a bizarre way, a glimpse of normalcy. You know, you were seeing how the Department of Education with the current administration was coming out, mostly in the post-secondary level, at the college level. And you were reading about like Columbia, you're reading about Harvard, and you're like, they just stop, right? They just turn off the spigot. Funds are frozen. You're not getting anything. You're not getting any research grants. Now, they weren't messing with Pell Grants, so it wasn't 100%, but you're talking about major impacts on schools. Not the way the Office for Civil Rights ever proceeded in the past, right? It was always pretty standard. A complaint is filed. A district is contacted if the complaint is, plausibly has merit. An investigation proceeds. Then within that investigation, in the past maybe 8 years, if there was a likelihood, if there was the possibility that there was a violation, OCR would notify you and say, hey, we think that there might be a violation. Do you want to try to resolve this with an agreement? Especially, in Michigan. That was the enforcement office was in Ohio. That's where I was working. And you'd say, well, maybe you'd reach the 302 agreement before a finding. Then if you didn't, OCR would go towards a finding, and they'd say, the evidence supports the finding of a violation of the law. This is the problem we found. Now we're not asking you to sign an agreement. We're telling you you need to sign this agreement, more or less exactly how it's written. And there'd be a negotiation period. And if you chose not to sign the agreement, there was an enforcement process. But the reality of it is that usually through the negotiation, or one way or another, you never got to the enforcement process. Now, the enforcement process, there was one mechanism, and that was the withdrawal of federal funds. Whether that applied to the program that was involved or whether it applied to every program in the district, there was room for debate. But basically, there was a really big stick, right? And that was all federal funds going to the district. But what's important about that is thinking about the order of operations compared to what had been going on in the last couple months, right? It used to be turn off the spigot, give notification that we're going to investigate something, and start the investigation. So basically, they would fire, and then they would start aiming. Whereas traditionally, OCR would aim, and then they would fire. And it looks like there's a move back to that. So it started out with this Evanston case, a more traditional, hey, a complaint's filed, OCR is going to investigate the complaint. OCR is going to see what's going to happen and then determine what are the appropriate next steps, which is, I think, there is a positive takeaway for the school from this in that they're giving you notice that that something might happen before they do something, which sounds crazy, right? Of course that's how it should work. But this is new again. So this is what's alleged to have been going on in Evanston. This is a lot of stuff. Some of these things, racially segregated privilege walks just off the bat, is your district doing all of these things? And there's other stuff that was going on here that's not listed that the department might not be dealing with, but so they're still picking and choosing. These are, at the end of the day, these are press releases, which the Biden administration did very bombastic press releases as well. But you could look at what they're focused on. And this is, regardless of where you stand on the appropriateness of all these things within the constructs of a traditional interpretation of Title VI, you could see how much they're talking about. And that's important because basically no one works at OCR anymore, right? I mean, that's an exaggeration, but not a huge one. There used to be a Chicago office, which this case would have been handled by. Chicago office was, I believe, by receipts, they were either the most or the second most compared to the California office. They did a lot of work. That office is closed. There's no one in Chicago anymore. And they did all the states that were around Illinois. Similarly, more relevant to you guys, there's no Cleveland office anymore who handled cases in Ohio and Michigan. All those cases are funneled to Denver. Denver has approximately 20 attorneys right now, and they're still there, but there are 20 attorneys dealing with thousands of cases in that office right now. So we will see what happens on how fast they can process this case in a traditional means. That would mean that there's going to be a data request, right? Though, so you guys have seen this. OCR will request data. They have request data. The school will have, 2 weeks to reply, but they're going to say we need more time. They'll get more. Traditionally, they will get more time. There will be interviews. This investigation, if it's done in a more traditional way, which it's set out to look like it might be, could take a really, really long time. And they chose in a district that had a very long list of things to take issue with.
One of the takeaways that I would emphasize from that list of items too is that to the extent that your organization is engaging in those kinds of things, for whatever reason, I would suggest that if we are not going to fight the fight with OCR and the U.S. Department of Education, that I would be looking at these kinds of practices and seeing whether we think it's appropriate to continue them or whether we should discontinue them. One of the statements that we've been making in our group is I would say tall grass gets cut, right? Given the reduction in force at OCR, I am skeptical that there's going to be enforcement appetite from the U.S. Department of Education for every minor transgression that gets out there. And so there is a certain amount of safety in not sticking out. And so to the extent that you're engaging in this behavior that is specifically being cited by this U.S. Department of Education as problematic and worthy of enforcement, then I would look at those practices and see if there's something that we can do about them if you want to avoid that fight.
Yeah, and I would go even farther in saying that, this is, and this will also depend on your district's risk tolerance. And that is, so here's your cheat sheet, right? Here's your cheat sheet of language that's gonna upset the sensibilities of the Office for Civil Rights. Do you do any of these? Do you do one of these? Do you do 4 of these? Do you do all of these? If you do all of these and you're not looking to, take the fight, you probably want to talk to someone like last week or, like this afternoon. If you're doing one of these, to Adam's point and to what I was trying to get at in a much less articulate way, there's only so many bodies to do this enforcement right now, right? And that's probably what prompted this whole, revitalization of the False Claims Act stuff. So they're not going to be able to get everyone that's doing every little thing. And another tell on that is that's why they went to the states, not the local districts. They're trying, there's just not enough bodies there to do traditional enforcement at every school. It can't happen. There's not enough people to even pick up the phone and make the calls or issue the letters. So, structure your risk as is appropriate for your district. But if you have this entire list, if you're doing all these things, let it be known that you may be the tallest blade of grass in that situation. And then you have another enforcement action against Chicago public schools. When Adam and I were talking about this case, what I would say to you, knowing that we have a Michigan audience, is that are you Chicago public schools? No, you're not. Has this administration expressed a special reserve level of concern, I guess is the most generous language I could use, for the city of Chicago? I mean, has there been a lot of rhetoric about Chicago? Chicago was a target. And so here's an example of something that, at least at first glance to me, and again, every district's community is different. Everyone's gonna have their own take on it. But to me, this seems like something that is not as extreme as the laundry list in the previous example. So you have something that a school is doing, to focus on, well, educational outcomes for Black students. I think a lot of districts may have that. Now, does that make you the tallest blade of grass? To that, I would say, and this is kind of where Adam and I, differ in some areas. I would say that, it's not great if you have it from a compliance standpoint at this moment, or not even from a compliance standpoint, but from the standpoint that you may have to explain yourself. But what I would say is that look who they chose to go after. And I think that is really related to the limited enforcement resources that exist. So you could expect schools like Chicago, like New York, like LA Unified, like San Francisco, like Oakland. There's going to be some schools that, man, they're going to be walking on eggshells. But it's not going to be every school simply because there's not enough bodies to do it. Again, hence the certification requirement. So I'm going to turn it back over to Adam.
So one of the things, and this touches a little bit on the question that we answered earlier, as it relates to, are we already, is there already False Claims Act liability for Title VI? And the answer to that question is yes. And the reality is that education budgets rely heavily on federal funding. Whether you're receiving funds under IDEA, Title I, Title II, if you've received ESSER funding, you have been a federal recipient in almost all circumstances. And so ultimately, we recognize our school districts are going to be accepting these monies because they're so important for the education and operation of a K-12. The concern that I have, the anxiety, what I'm worried about when we talk about this fight continuing over time is, how is the administration going to update, modify, or deal with certifications on a going forward basis? So when we were talking about all the litigation earlier, we were talking a lot about how those things are procedural, about how the how they did it was the problem rather than the why, because I think the merits are a little bit more difficult. And the concern that I have and the anxiety that I have is that once we go through the consolidated application period this year or next year or in the future, that the administration will have taken more steps or appropriate steps in order to insert some of these certification requirements into those consolidated applications for federal funding. And so to the extent that we are federal recipients, and I'm not aware of a K-12 in the state that's not a federal recipient in some way, shape, or form, that is an area that I would be scrutinizing as we look towards the future. Look at what those application materials actually say, and I would be starting to think through what it would look like for us to consider complying. As I mentioned earlier, one of the problems that we faced with this particular request for certification back in April is the timeline. It was not realistic or possible to make the kinds of changes that would have been demanded in order to make and certify according to what was requested by the feds. But I think that now, in the summer months in particular, are well designed for some of that thinking, that even if we aren't prepared or ready to make an immediate change, that we've thought a little bit about how we'll be able to deal with those things in the future as well. And so this, again, we're a little bit of good cop, bad cop between Dan and I. I'm the pessimist in this case. I'm very concerned about living in an atypical world, and then how this administration is going to fit these ideologies into upcoming certifications. And I'm also concerned that they're going to turn off the spigot of funding like they have at some of the post-secondaries for either some of the states or some of the locals. I'll be watching the federal legislation as it relates to budget very closely this cycle and then in future cycles, because I think that's an area where there might be some legislation associated with reconciliation that could put some risk on our districts. Dan's got a little rosier outlook than I do.
I mean, I don't know if it's rosier, but I think this is also a good time. We got a question about, is there a greater risk for investigations for ISDs compared to local school districts? So I have kind of the cynical take on it, and then the less cynical take on it. One is that, from having been in the space where where the Department of Education was looking at multiple states, where I was looking at multiple states, the setup in Michigan it's not typical with the way it's run with the ISDs and the recent. So it was something that the Cleveland Office for Civil Rights had some expertise in, and understanding the relationship between the ISDs and the districts. And then when it goes to the state, there's, the people doing enforcement in Michigan now have very likely never stepped foot in the state, much less know the nuances of like the educational setup, in the state. So candidly, I think that your enforcement's going to come from people with Google, and they're going to see district, and they're going to think district. I think that's the reality of it. As far as what that could look like, I think it's all the same. I mean, something that it's not in this presentation, but something that Adam and I have talked about a bit is that goes along with the highest blade of grass, is how out there are you on these issues? What happens if someone goes to your website and types in DEI? And what are the position titles, and what are those things? I think those are the things that put you most at risk. I don't think that the U.S. Department of Education, Office for Civil Rights, both based on their lack of local knowledge and the fact that this is, more of an ideological, mission than anything else. I don't think that there's a significant difference between whether they're going to target an ISD or a district. And to the extent that they realize you almost might get more for your money targeting an ISD, I don't think, depending on, if this thing gets more than 3 hits on YouTube, I don't know that they're gonna, I don't know that kind of narrow targeting is going to happen. I do think that, Michigan, when you're considering, where does Michigan stand in this enforcement, and this is related to this slide too, is, it's a very unique state in how it votes, where it stands as a manufacturing hub, and how much, how targeted is Michigan going to be? I mean, the Department of Education really, it was a strong letter, and I think that it was a relatively well-publicized letter saying pound salt with respect to the certification requests we already certify. But there were enough other, there were enough other states in there that you're kind of part of a herd, a pretty big herd. And, to turn off, Title I funds for half the country, especially half the country that voted for the folks that would be doing it, this is where, I have a slightly, to call this rosy is maybe not the best word, but where I have a rosier outlook than them. I think you have a lot of cover with MDE. I mean, I think MDE is they're gonna be chewing on MDE for a while, is what it looks like. And then to the extent that they're gonna be looking at districts, it's either gonna be districts that have, a very, very sophisticated complainant, like the first case from Illinois that we talked about, or a district that, is that they've been salivating over, for the entire election cycle. So, I think that regardless of whether it's an ISD or a district, I think that you're looking at, as it relates to the schools right now, as it relates to, after the State Department of Education, you're looking at, you're going to get a heads up. You might get a chance to negotiate. MDE, let's say that you guys are loud and proud with it. You're like, this is important to us. This is important to the values of our constituents. MDE is taking a lot of these arrows for you guys. They came out there and they said it like our schools are good. We're fine. We're doing what we need to be doing. To the extent that, you're looking at, you are relooking, you're evaluating your programs and maybe you're looking for a way to remove some of these DEI programs. I think what Adam's talking about is this is probably coming, right? This fight is not, this is a pause in the fighting, at least from where we sit. The attorneys generals are not pausing. That is full on. That the fight is happening. And at the same time, and like Adam said, he's keeping an eye on it. If the Department of Education, it's not going to, an executive order is not going to do it. A dear colleague letter is not going to do it. But doing a proper process through the Administrative Procedures Act, that will do it. And there is no reason to think that that will not happen. But as of now, it hasn't happened. And you have different courts with different judges saying, this is too far. Your interpretation of Title VI is bonkers.
So I'm keeping an eye on the clock, and I know we're near the end of our scheduled time. So we've got a handful more slides to deal with, and some of these things are reiterating things that we've already talked about in the course of the discussion so far. Ultimately, as it relates to all the lawsuits that are pending and outstanding, it's too early to know the outcomes. We expect there to continue to be a fight and for this administration to push and find a weak spot in the legal decisions. And as we've reiterated about a dozen times at this point, the wins so far have been largely procedural. Not a whole lot on the underlying substance related to the interpretations that are being put out there. And then, of course, my anxiety about what certifications look like for the 25-26 fiscal year and in the future beyond that. We did also want to note, I know MDE sent out yesterday or the day before a press release related to a couple of court decisions. One related to the extensions for COVID-19 pandemic relief funds, and then another related to the granting in order to stop the closure of several federal agencies. Losing track of it at this point. We're keeping an eye on those, but they are a little less relevant to our discussion today. But we did want to note those because those recently were shifted to or sent out to the whole state. And then finally, before we get to the very end, what does it all mean? And we love to be lawyers. We like to joke about that. And I know we said we would do this at the outset. The answer for each individual is going to be a little bit of it depends. So our magic 8 ball at this point, it is the special lawyer edition, but we did want to spend some time with this group and others in order to give you a little bit of an idea of what we're expecting to see in some areas where you might want to spend some time thinking in the coming months so that you're prepared for what we think is coming next. Dan, any last words?
No, I mean, I think this is a situation where it'd be great. I think everyone would hope that we could just say, with the certifications, everyone want sign this, don't sign it, sign some other thing, do something. These really, it's not that there's not a path. There is a path. It's that what path is appropriate for each district or ISD is going to be, a unique analysis of the factors for them. And it's going to depend on your community. It's going to depend on your risk tolerance. It's going to depend, not so much on reading the tea leaves, but, the unique factors that you're dealing with where you are. So that's something that, we're happy to talk to anyone about. And no, just thanks for giving us an opportunity to present on this. I know this is stressful to everyone.
All right, with that, we'll adjourn for the day. Let you get back to it. Thank you for spending your lunch with us today.